The Delphi evidence leakers case will get dismissed. Pretty bold statement, right? Let me explain myself. It's basically agreed that Richard Allen's original attorney, Andrew Baldwin, had a friend named Westerman who Baldwin allowed to come into his office. It's also agreed by everything I've seen that Westerman, without Baldwin's knowledge, took photos of the crime scene and then gave those photos to various other people, including podcasters and YouTubers. Now, on November 21st, State Trooper Rector wrote up a probable cause affidavit alleging that Westerman committed conversion when Westerman took photos of the crime scene photos. A prosecutor then wrote up the criminal charges that same day, and then on that same day, a judge signed off on the charges of criminal conversion against Westerman. Now let's back up. What is conversion? Conversion is a very simple way of saying that a person knowingly or intentionally exerted unauthorized control over the property of another. Criminal conversion is an A misdemeanor with a maximum time in jail of 1 year. Now, conversion and theft are very similar, but theft alleges that the person intended to deprive the other person of any or all of its value of use of the property. Theft is also an A misdemeanor unless certain conditions apply, then it can become much more serious. So the state trooper probably recognized the taking of a photo didn't really deprive the other person of any part of its value or use. So the trooper probably thought that criminal charge of conversion was a safer bet. And that makes sense. Taking a picture of a picture doesn't make the original picture any less of a picture or interfere with its future use. The picture is still there. So now that we know what conversion is, let's look at exactly what the state of Indiana is trying to say Westerman did. Now here's the charging information. Between August 1st, 2023 and October 5th, 2023 in Johnson County, state of Indiana, Westerman did knowingly or intentionally exert unauthorized control over the property of Andrew Baldwin, to wit, images. Okay, number one, I don't believe the images are owned or are the property of Andrew Baldwin. I believe they're owned by the state of Indiana, and the pictures were loaned to Baldwin as part of the criminal process called discovery. Why do I feel that way? Well, lots of reasons, but in a subsequent hearing with the trial judge ordered Baldwin to return the property to the state of Indiana, specifically the prosecutor assigned to the case. If Baldwin owned the property, then the judge wouldn't be able to do that. But this can actually be fixed by the state of Indiana pretty easily. The state can just move to amend the charging information to substitute Baldwin with state of Indiana, or even Baldwin and or state of Indiana. So while this, in my opinion, is a mistake, it's not a fatal mistake unless it goes this way to trial. No, the real problem with this case has to do with the phrase exert control over property. You see, Indiana defines what exert control over property means. Indiana Code 354341 says exert control over property means to obtain, take, carry, drive, lead, away, conceal, abandon, sell, convey, encumber, or possess property, or to secure, transfer, or to extend a right to property. I don't see any way, shape, or form that taking a photograph of a photograph fits with this definition of exert control over the property. Why? Westerman took a photo of a photo. That is not taking, carrying, driving, leading away, concealing, abandoning, selling, conveying, encumbering, possessing property, or securing it, transferring it, or extending a right to it. He simply took a photo of a photo. What Westerman did does not fit into the definition of exert control over the property as required under Indiana Code. Now, I know some of you all watching this are super state friendly and will say, Mark, taking a photo of a photo clearly fits with the definition of exert control over the property. So I'm ready for you. I want to talk to you all about a case of Coleman v. Vukovich. It's a 2005 case from the Indiana Court of Appeals written by a still sitting Court of Appeals judge, Nancy Vadic. In this Coleman case, one party is accusing the other of copying a computer program and was suing civilly for conversion. Conversion civilly is the same as conversion criminally. The Court of Appeals held that conversion did not occur for two reasons. Number one, the party suing for conversion did not own the computer program. They only had a license for the use of the computer program. And number two, the alleged copying of the program did not impair the suing party's ability to still use that computer program. Those facts and rationale sound eerily like the case against the Delphi evidence leaker. The photographs were not owned by Baldwin, merely licensed to him by the state of Indiana for the purposes of criminal discovery. and taking a photo does not impair the ability of anyone to use the original photo. Now, some people might say, now wait a second, Mark. A police officer, a prosecutor, and a judge signed off on these. Surely Mark doesn't think he's smarter than any of them. And you would be right. I don't think I'm smarter than anybody. But I, just like the judge and the prosecutor, understand probable cause. Probable cause is determined to exist when the facts and circumstances under an officer's knowledge, which is reasonably trustworthy, warrants a man of reasonable caution to believe an offense has been or is being committed. This definition involves a reasonable ground for belief of guilt. This is less than required for a conviction. A police officer, prosecutor, and judge reviewed the police report and said, it looks like a crime occurred. And that's all that is necessary to bring about charges. That is how our criminal justice system is designed. But the filing of charges does not mean a person is guilty. That's just the start of the case. And I think this is going to be a fun case to watch. Now, I am not advocating that what Westerman did was right. He clearly betrayed the trust of Baldwin, and taking photos of evidence he knew he should not be taking raises all sorts of ethical questions. But not all bad conduct is criminal, no matter how strongly we feel it should be. In closing, I predict that the charges will either be dismissed entirely or that some other more fitting charge will have to be added. If you've watched this far, don't forget to like this video and subscribe to my channel. I will do my absolute best to respond to every single comment anyone leaves me. And most importantly, remember, always plead the fifth.